All right, our next talk, we're going to follow up with Marcia Hoffman and Kurt Opsahl. They're going to be talking about legal consideration for cellular research. And I just want to mention again, when you leave the room, be sure and touch your badges at the door so you can fill out the surveys. They'll be emailed to you. And if you have questions on the follow-up, there's a microphone over here in the aisle. That way you can be on the recording so that everybody listening from home can hear, and they'll be able to hear you better too as well. Marcia and Kurt?
Thank you everybody for coming. We're here today to talk about legal considerations on cellular research. A lot of people are interested in doing research on cellular communications, especially with femtocells, that now you can go onto eBay, you can buy a device that will mimic a cell tower and have it in your house. This makes it an interesting target for security testing. So what we're going to talk about today are some of the unique legal considerations that come up in this context. Some of the laws that you're going to be aware of. And the reason for this is not to teach you everything that you possibly need to know about this, but to help you with spotting issues and know when to ask for further questions. So this is sort of a shallow dive in a very deep ocean. And the other thing we want to talk about is ways that you can mitigate the risk, ways that you can conduct research which will be less risky than if you didn't know about them. So what do I mean by risk? Risk has a couple of components here, what we're talking about. And so one is practical risk, and the other is sort of legal risk. And by practical risk, this is somebody going to sue you? Does it seem like it is threatening enough to make it worthwhile to go to a courthouse and to initiate legal actions? Is it threatening to their business model? If you are doing as a security research for a presentation in an academic forum that has sort of a lot of what we call atmospherics, this is going to make it sort of a tougher decision for someone to want to sue you because they'll kind of look like a bully. And then the second consideration is, well, what if somebody does sue you? How's that going to look before a court? What is the court going to think about the legal issues that have arisen? So there's, of course, a disclaimer. This is not legal advice. And part of that is about this, not just a disclaimer for what we're giving, but to remind you that it's about issue spotting, trying to understand the overview so you can look deeper and then ask a lawyer about your specific circumstances. So what makes cellular research a very, very interesting thing? Well, there's a lot of factors that go into what makes it interesting. You have a whole bunch of different devices that are connected to each other that are part of it. So you would have a device which is the phone, and connecting to a device which might be a femtocell or a cell tower. And then this is connecting to something at the facility of the telecommunications providers. There's a lot of different players that are involved in this. You have the manufacturer of the cell tower, the femtocell. You have the manufacturer of the phone. You have the person calling, the person receiving the call, the NSA agent listening to the call. A lot of different people have an interest in this. And they all might have a different reaction to the research, depending on whether their aspect of it is sort of coming under threat. And then another thing is embedded software. A lot of these devices have software that was perhaps licensed by the device manufacturer, so it's yet another party who has an interest in this, and they may claim a copyright in that software. So we're going to give a brief overview of some of the legal considerations, but it's important to note this isn't an exhaustive list. For example, we're not going to talk about patents or trade secrets, even though some of these things may in fact be patented. And we're not going to talk about wireless spectrum, except to sort of note that it's an issue. So one of the main laws that one should be aware of when you're dealing with anything involving telephony is eavesdropping laws, and that's covering sort of the content of the communication, what people are saying to each other. And there's the Federal Wiretap Act that this came around from the late 60s to regulate when the police can listen into phone calls, but it also regulates when others can. And then each state has their own version of eavesdropping law that has variations. And then you have the pen register tap and trace. And this is for routing and addressing information, the dial digits. And the Federal Pen Register Act covers how the police would get this and prohibitions on others. And then, of course, states have their equivalents. So some things that might be potential issues is the states will have various laws. 50 states, and they have variations on each, and they might treat text, audio, and video differently. For example, here in Nevada, text messages will be treated slightly differently from phone calls. And some states go so far as to say you need consent to disclose the existence of a communication, as opposed to disclosing the contents of the communication, which is much more widely regulated. Some states have special laws about connecting to telecommunications facilities. So, for example, they might have a regulation saying you can't connect to a telecommunications facility with intent to defraud and with intent to not pay the ordinary price. This is sort of trying to deal with the Captain Crunch whistle issue. And as I mentioned, wireless spectrum is outside of this, but if you are broadcasting something over a ban on wireless spectrum, that issue is raised. So if you're inspecting packets, if you're looking at the content of the communication that goes by, one of the more important things is, are you in a one-party or all-party jurisdiction? Federal is one-party, so you're at a minimum in a one-party consent. But many states have all-party consent. Sometimes people call this two-party consent, but that's a little bit of a deception because if there's more than two parties, then you need to get all of them to consent. Other things to watch out for, if you're breaking encryption or descrambling, this will raise some issues. And you have laws that are, well, frankly, outdated. A lot of these laws started out in the 60s, where maybe some of them were modified in the 70s. Some of the electronic communication laws came about in the mid-'80s with a very different conception of how people were communicating. Thinking about like BBSs and modern email was not part of the conception there. They have been modified over the years, but Congress is not very good with adjusting the law to keep up with the speed of technology. Another set of issues, contract laws. You'd be amazed how many contracts that it's going to be asserted that you've agreed to over the course of any given day, but especially in the course of dealing with cellular phones. And so you're going to have end-user license agreements. You're going to have software development licenses. Terms of use. You have terms of use for your carrier. You have contracts with involving when you got the phone, when you got your femtocell. If you bought it off of eBay, you might have a different contract situation than if you got it from your provider. So check to see how many agreements are going to apply to your research. And keep in mind there are nested agreements. So an agreement may refer to another agreement and say that you've agreed to that as well. So look through the agreements carefully, and you're going to end up with a stack of them that you're going to want to review. So what happens if it goes wrong? Well, sometimes you might be in a situation where what you're doing is not kosher under the agreement. And that can lead to a civil claim. They can sue you for breach of contract. In those cases, you have monetary damages, so to sort of make the other contracting party whole for their loss. And in many circumstances, this is not going to be, sort of a tremendous amount of money, but it could mean that, for example, that your account was terminated with your cellular service provider. So if it's like your main account, your main phone number that everybody knows you by, that could be a little bit awkward. And then in some places, you have another issue involving with contracts. If you violate the contract, it may implicate computer crime law. And with that, I'll turn it over to Marcia Hoffman.
Thank you. Good morning, everybody. I'm so glad you came out to our presentation. So, one problem potentially with violating a contract that kind of bleeds over into another area here is the question of whether violating a contract like that could make your access to a device or a service unauthorized for purposes of the state and federal hacking laws, all right? So the laws that we're talking about here are first the federal law, the Computer Fraud and Abuse Act, and a lot of states have a similar law, and the language may be a little bit different, the terms they use may be a little bit different, but the basic idea is generally the same, which is that if you are accessing a computer and you don't have authorization to access that computer, or you don't have permission, or you don't have consent to access that computer, then that is illegal. And something that's important about that is that these laws generally have civil penalties, meaning that somebody could sue you over this, but they're also criminal laws, which means that you could be prosecuted and you could go to prison. So to give you a sense of sort of the problematic language, the federal law, here's the broadest, most troubling provision of the Computer Fraud and Abuse Act, and the one that often is kind of twisted in some concerning ways. What it prohibits is intentionally accessing a computer without authorization or in excess of authorization, and thereby obtaining information from any protected computer. Now, the way that this law has been interpreted, the concept of accessing a computer is extremely broad. And obtaining information is also construed very broadly. A protected computer is virtually any computer except a calculator. I don't know why. Congress really very specifically called that out. But the only limiting principle here really is this concept of without authorization or in excess of authorization. And so it's really important for that to be construed narrowly by the courts, because otherwise this just turns into this huge sinkhole. Now, certain people have tried to creatively use that broad language to say that if you access a device and breach a contract or violate terms of service when you do that, then that becomes unauthorized access. And what that basically does is turns breaching a contract into something you can go to prison for. And I'm not going to get into that a great deal because I'm actually going to do a briefing all about the Computer Fraud and Abuse Act right after this in Palace 3. And if you're interested in these issues, please come and we will discuss them to your heart's content. But it's just something to flag because this is something that has really become an issue over the past several years, and it's very much an open question. And so anytime we see a situation where somebody is violating a contract, at first your thought is, well, it is breach of contract, okay, but then you also have the concern that that could turn into a much more serious problem down the line because of the computer crime laws. Okay, the next legal issue we're going to talk about is the Digital Millennium Copyright Act. Now, this was a law that was passed in the mid-90s. It was sort of intended to update copyright law in light of the new digital content out there on the internet. So 2 basic prohibitions to keep in mind. The first is you can't circumvent technological protection measures that have been put in place to protect or control access to copyrighted works, okay? The second thing is you can't traffic in tools that are primarily designed, marketed, or valuable for circumventing these technological protection measures. Now, the question of what a technological protection measure is a little bit of a difficult one. It's pretty clear at this point that authentication handshakes, protocol encryption, these things would qualify. But then there are a lot of open questions like, code obfuscation, proprietary protocols. Do these things count? And if you need to circumvent those things in order to do your research, what does that mean? I will mention briefly that there is a process every 3 years by which the Library of Congress is able to grant special exemptions to basically declare that a certain circumvention does not violate the DMCA. And in the past several years, EFF has successfully petitioned to get an exemption for basically jailbreaking or rooting your phone. Because we were able to show that a lot of users do that. There are lots of good reasons that people should be able to do that. We tried to get that expanded to tablets and also to video game consoles, and that was not permitted. That is not to say that jailbreaking or rooting those devices is illegal, I think. I think what that just means is that there's a lot of gray area there. And frankly, if you need to gain root access to any other computer, if you need to circumvent a technological protection measure in order to do that, there's some gray area there. That's just what that means. So there are some important exceptions to keep in mind about the DMCA and this prohibition on circumvention. Many people are familiar with the reverse engineering exception. There's an exception for reverse engineering when you are doing it for the sole purpose of achieving interoperability achieving interoperability between a program and another program. So this is something that actually I think a lot of security researchers know about, but it's important to understand that it's actually a fairly narrow exception that's solely for purposes of interoperability. It's not sort of a general all-purpose, you can reverse engineer for anything. There is also an exception for encryption research. Again, this one is fairly narrow. It requires that you make a good faith effort to obtain authorization before you do the research. And so, that's something that might apply in some situations, but it doesn't apply in all situations, certainly. There's one for security testing, but it requires that you have authorization. So again, that's one that might be useful in some situations, but it may not be useful for a broad range of security research. There's one that a lot of people don't know about, and I think it's actually potentially really useful. There is an exception for circumventing a protection measure that is in a device that is capable of collecting and disseminating personally identifiable information reflecting online activities. And this is one that is, it's not often used. And I think a lot of people don't know that it's out there, but it's something that could potentially be useful, I think, in a range of security research. And so if you are doing any research that involves devices like that and information collection and dissemination, devices that collect and disseminate personally identifiable information, you should talk to a lawyer and see if that's something you can use. Okay, so how do we design safer research? Based on these laws that we're dealing with and the lessons that we've learned, the first thing you should do is identify and read any applicable agreements that might apply to the devices or the services you're using before you begin your research. If you can avoid agreeing to them, don't agree to them. One thing that we've noticed over the years is that it is possible sometimes to buy devices off of, say, for example, eBay, and that may put you in a situation where you are not having to agree to things that you might have had to agree to if you were buying directly from the manufacturer or from a store. Test on your own devices, accounts, data, communications, if possible, because you are in a position to give consent, right? Or get permission to access the device, accounts, data, communications, because again, you give consent, you have permission, you have authorization. Crypto, descrambling, bypassing, protection measures, these are sticky areas, and you should talk to a lawyer before you do these things to see how you can do them in a way that safely navigates the legal craziness there. And when studying other people's code, consider asking permission even if you don't think you'll get it. Because in situations involving, for example, encryption research, that might put you in a position to take advantage of a DMCA exception where you otherwise wouldn't be able to. Okay? So, questions? I think we have a microphone over here if anybody wants to come. Great.
I have one. It might be a little bit off. I'm wondering about the legal implications of selling the fruits of our research, the vulnerabilities or exploits as a result of that.
The implications of selling.
Do you want
So this is a little bit different for we're trying to hit the legal issues of doing the research in the first place, but just sort of to briefly cover that. There are a couple of issues that might arise in the context of selling research. One to be sort of careful about is sort of the way that it is framed in the sense of if you are taking advantage of an established bug bounty program, that's going to be fine. If you are going to a provider and saying I have a way that will really be damaging to your technology and you need to pay me a lot of money or I will publish it, then they might start to feel like this was putting undue pressure on them and thinking about extortion or things like that. Which is, I'm not saying that they would have a particularly good claim there, but you don't want to get into a situation where that's where they're thinking it's going. And then you have considerations about where to sell it to. What is know your customer, know who you're selling to, and that it's someone who you want it.
I was actually more interested in not the manufacturer, the OEM, or the bug bounty program. I was more interested in third parties.
Into third parties. There's a number of places that do this. So, one of the things that we thought about is on the know your customer end of things. That if you're using it, you don't want to be selling something to someone who's going to turn it into malware to the detriment of people. And there are some places where there are export control laws that will come into play. So there are certain countries that you wouldn't want to be selling to.
Thank you.
Is the situation any less bleak for publicly funded academic research? Are there...
Sure. Go ahead.
Well, I think this goes back to the question of atmospherics. I think that if you are a researcher doing, publicly funded research, or you're an academic, you're an established security professional, I think that those are good atmospherics, and people are probably less likely to create legal trouble for you, right? I think that you start to run the risk of attracting attention that you don't want if you are doing research that is not very sympathetic, or it doesn't look like you're doing things in the greater good. But I think that the people who are doing research in an academic vein or sort of a public interesty vein are in a much better position as a general matter, because regardless of what their research is, they are people that we want to be doing security research, and I think that there are fewer people likely to take issue with it and make a problem for them. Did that answer your question or no?
Kind of. I was wondering if maybe there was some legal, if there are extra legal protections of some sort, as long as if you're not making money off of it and publicly disclosing.
So, the legal protections, where there are some, one place to look at that is in the DMCA research, but you have to fit within the research exemption. So merely being academic in and of itself doesn't do it. But if you look at those exemptions, and they have a number of detailed things, and one of the aspects for both security research and encryption research is how the information is presented, and whether it's presented in a forum that will sort of enhance encryption or enhance security. And so oftentimes, by sort of happenstance of how academia works, it will be in a better position. But it's not in and of itself because it's academic.
I understand. Thank you.
Can you elaborate on the PII exemption to, research, especially in regards to mobile handsets, or, mobile phones?
Right.
As we were just hearing, they're collecting all kinds of information.
Right.
And really, PII would seem to be on most embedded devices now, especially ones that consumers
That's
purchase.
absolutely right. So it's actually interesting. I looked at the legislative history of this because I thought, where did that come from? And Congress at the time was mostly concerned about cookies. Which I thought was interesting, but I totally agree that if you're doing research on handsets, it could come in very, very handy. It's kind of a long and complicated exception, but the basic idea is that if you're studying something, if you have something that is capable of collecting or disseminating personally identifiable information that reflects your online activities, that's kind of like a direct quote, reflects your online activities, and you are disabling it because you want to protect your own privacy, then you can do that. It is not written to be sort of very general or broad. The idea was that people should be able to protect their own privacy if they want to do that. If you have a particular research situation and you kind of want to talk through it to see if this might apply to what you're doing, we should probably talk about that a little bit later, but it's definitely something to keep an eye on, because I don't know that many people really know about it or take advantage of it.
Okay, so it's specifically targeted at protecting your own PII.
Right, but I do think that a researcher could, be disabling it to protect his or her own personal information or his or her own privacy in the course of security research, for example.
Thank you.
Any other questions? All right, thank you. We'd really appreciate any feedback if you have it. So if you think that we did a particularly good job here, a particularly bad job here, please go ahead and submit feedback. We'd really like it. Thanks.
Thank you very much.